Program I am Ian Kitani. Now, the High Court has today upheld the Conservatory orders suspending the implementation of the Finance Act 2023 until the matter is heard and determined. Giving the ruling virtually, Justice Mugure Thande dismissed the application which the state sought to set aside the orders. Of course, she had issued suspending the act. Now, Judge Thande says the state did not give sufficient reasons to warrant her to lift the orders. The judge has also forwarded the file to the Chief Justice Martha Koome to empanel a three-judge bench to hear the petition. The order has been extended pending the hearing and determination of that particular case.
The contentious Finance Act remains shelved on the corridors of justice after Justice Mugure Thande on Monday dismissed the application by the state, which sought to set aside the order she had issued early suspending the act. While giving the ruling, Justice Thande said that the state, which is the respondent in the case filed by Busia Senator Okiya Omtata, did not give sufficient reason to warrant her to lift the orders.
54 of the Constitution. So in the end, and in view of the foregoing, I find that it has not been demonstrated to my satisfaction grounds to warrant the setting aside of the orders of 30th of June 2023. I make the following orders. The applications dated 30th of June 2023 and 1st of July 2023 are hereby dismissed. The application dated 29th of June 2023 is hereby allowed. Pursuant to Article 165(4), this matter is certified as raising a substantial question of law, and the file is hereby transmitted to the Honourable the Chief Justice for assignment of a bench of not less than 3 judges to hear and determine the petition. No order as to costs.
The state had argued that the suspension will bring a budgetary crisis to the government, arguing that the government continues to lose 578 million daily in taxes since the orders were issued on June 30th.
We ask you to exercise the constitutional power that you have and the discretion conferred on you by law to grant a temporary order of stay to allow all the parties aggrieved to move the Court of Appeal for appropriate orders. Malay, that will not invalidate the decision you have made today. It will only keep it suspended for the period that the parties will be able to move the Court of Appeal. And Malady, that will be a balancing act.
Justice Thande ruled that the petitioners Okiya Omtata and Otiende Amolo had proven that they have a case, adding that if the orders were to be lifted, the public stands to suffer. While making the ruling, the judge also noted that if the orders are not reserved, then there is a danger in rendering the case an academic exercise. She said that lifting the Conservatory orders will be against the public, as there will be a real risk of the public being subjected to unconstitutional laws that have been challenged in court.
Public interest requires that this court must discharge its constitutional mandate of protecting the supremacy of the Constitution by ensuring that all laws conform to the Constitution. The matter before me is a challenge on the constitutionality of a statute. According to the respondents, it is tried jurisprudence that every statute enjoys presumption of.
In their submission, the petitioners Omtata and Amolo argue that the state will suffer no harm if the orders are extended and Conservatory orders issued. They claim that some sections in the Finance Act threaten the right to property, access to justice, and violate the Constitution in general.
Are not true because the Finance Act 2023 has not come into effect. That will only happen in the event you suspend your orders, my lady. It will bring that act into effect, and then whatever they're complaining of, or whatever they're relying upon will happen. So far, the Finance Act 2022 is intact. And given that the Finance Act simply gives measures for raising revenue, the government will continue raising revenue using those measures that have been given in the Finance Act 2022.